mortgage fraud is the biggest financial swindle in the history of the world. And why the government has done nothing to prosecute the guys responsible is pretty stunning. These are difficult cases. I was a federal prosecutor. I know quite a bit about fraud. I was at the SEC. I know what it takes to bring a securities fraud case.
The banks are out there advertising their willingness and their happiness to do loan modifications on their websites. Go to any bank and you'll see websites that say to things to the effect of, we're here to help you. Please come to us. We want to help you. And people are relying on that. They have hope because of that.
We've all had clients who are willing to take a modification to continue paying a loan, which is higher than the worth of the property. Why would you discourage those people? Why would you maltreat them so that you can recapitalize, you can subsidize the kind of guys that instituted this predatory lending and this brutish behavior? It's really pretty stunning.
If you go into any courtroom in the country where a homeowner is bringing a lawsuit against their bank, you'll hear pretty much the same storyline coming from the bank. And the bottom line of that storyline is the borrower is a bad person because they're not paying their mortgage and all they want is a free house. That's the line in every courtroom for every lawsuit that's going on in this matter. And so part of it's just an education process that people have to understand that the vast majority of those people who are in court trying to get justice are not there to get a free house. They're there so that they can remain in their home in a reasonable way.
I started my career at the United States Securities and Exchange Commission, investigating and prosecuting securities fraud cases, which time I interviewed lots of victims of stock swindles. I became the chief of enforcement there. I went to the United States Attorney's Office in San Francisco, where I was a federal criminal prosecutor for 26 years. Headed a fraud task force, did commodities and securities prosecutions, and did a number of white-collar, money laundering, tax kinds of fraud cases. I'm very comfortable with investigating and prosecuting companies that commit fraud. And I've got plenty of trial experience, plenty of appellate experience in federal court. So I'm comfortable in this area.
I've been practicing in California for 25 years. The first 15 or so years of my practice, I started at a law firm as a law clerk and worked my way up to senior partner of a fairly large Orange County boutique law firm. I retired for a while. When I came back, I started working on the consumer side. At the time I worked for my old law firm, I worked on behalf of multi-billion-dollar companies. I decided I wanted to work on the consumer side of law. I'm also a licensed real estate broker in the state of California, and I have a lot of litigation experience. I don't have a client who wants a free house, but I have lots of clients whose families live in that home. It's not just a house to them, it's a home. And for those people, it's the roof over their children's head. And all they're looking for is a fair deal, like they're being told they're entitled to, so that they can keep their families under that roof. And somehow we've turned those people into criminals, and the banks are the good guys getting all the money from the government. This lawsuit doesn't really deal with what people call the lost note situation or the MERS situation. The courts in California just don't like the argument. It's very disfavored. And I don't think it's necessary. What we're looking to do with this lawsuit is attack the servicers for the fraud that they are perpetrating in their servicing. They come out, they make promises, they offer to do things, they invite people into the process, and then they hurt those people. And my belief is, and Mark's belief is, that's actionable under California law. So that's the arguments we're bringing. We're not bringing hyper-technical banking and mortgage arguments. We're bringing old-fashioned fraud, breach of contract type arguments.
A properly pled fraud case can't be dismissed on a motion. Because if you allege that they committed fraud, unless they agree, then you get to go to court. And you get to prove it. And before you get to go to court to try to prove it, you get to do some investigation in what's called discovery. And we're prepared to do that because we don't believe that their practices can withstand scrutiny.
It'll be the first time that this servicing fraud will be tested in court. We're arguing that they have a responsibility when they invite a borrower into this process not to commit fraud against them. I mean, it's no different than if you went to buy a car. The car dealer is not allowed to commit fraud against you. California has laws and statutes that say that can't happen. So it's our interest to test why the servicers have acted the way they have acted for the last 2 years. It doesn't make any sense. There is no rational explanation for it other than they're trying to maximize the profits that they get out of the process by extending the process as long as possible and then pulling the trigger against the borrowers.
If they want to do it, they can. If they don't want to do it.
Mark's gotten loan mods for his clients. I've gotten loan mods for my clients. But that doesn't explain the number of loan mods that don't get granted for people who should have a loan mod provided to them under the rules stated by the banks as the rules they operate under. It just doesn't make any sense. And people have tried to explain it by saying, well, the banks got inundated with so money that it just was hard for them to do. Or that, there are new people that they've hired to do the work and they're just being negligent. Well, I'm not buying it. This has been going on for years now. This isn't rocket science. It isn't brain surgery. For somebody to look at a set of conditions and determine whether somebody is qualified under those conditions should take about 15 minutes after they've collected the initial documents they've needed to collect. There's no explanation for the process to take 16 or 18 or 24 months, except for the fact that during that period of time, fees and costs are growing, and the profits to the servicers are growing along with them. There's a document called a pooling and servicing agreement that exists between the servicer and the investor in every securitization of mortgages. And without getting deeply into it, because it's an extraordinarily complicated subject, one of the problems that exists is that that agreement provides the investor, the ultimate owner of that loan, very little say-so, if any say-so, in how that loan is serviced and whether truly a loan modification will be granted or not. And it's very difficult for for the investors to group together like they would have to attack a bank on any given loan. And that's one of the reasons that the servicers have been able to get away with what they've gotten away with, is because they don't have to worry about the borrowers, because the borrowers don't have any political power, and they don't have to even worry about their principal, the actual owner of the loan through the securitization process, because that person doesn't have a way to police their duties. And that's one of the huge difficulties, and it's what's allowed the servicers to do what they've done to not only to the borrowers, who Mark and I represent, but to the investors also.
It's shocking. It's absolutely appalling. This isn't the behavior of professional, grown-up, mature, responsible companies who don't have something to hide, in my view.
That person you talk to who answers the phone has no decision-making capability whatsoever. And you can't talk to the people who do have the decision-making ability. Well, it's with the underwriter. Oh, can I have the underwriter's name? Sorry, I'm not allowed to give you that. May I have the underwriter's phone number? Sorry, I'm not allowed to give you that. May I have the underwriter's email address? Sorry, I'm not allowed to give you that. So you can't actually talk in many instances with the decision maker. And we don't know what process that decision maker is making their decisions under. But we're looking forward to the opportunity to taking depositions of those underwriters and those decision makers to find out where they got their marching orders from.
Let's look at why it took you 14 months to say no when you or I or anybody could tell, a knowledgeable person could tell in 15 minutes. Why did you continue to send out requests for documents? Why did you say no for the wrong reason? Why didn't you grant this mod, which was plainly supportable on the facts?
As long as they're relevant and admissible, then the court's going to order them to answer those questions. I have clients whose level of frustration and emotional distress is so high because they just can't understand, but they want to write checks for their home and they just can't get anybody who's willing to allow them to do so. We've been working on the process for a number of months. We've probably done 30 different drafts of our complaint to get it exactly to the point that we want it to be. We've done a lot of research to determine whether the servicing issues that we believe exist do in fact exist, and after many months of work, we're ready to get started suing servicers. And it's our intent to bring lawsuits against all of the 5 major servicers.
Frankly, I can't wait to get some discovery going and find out, let's pull the rock aside and see what little white blind worms are down there, because they're going to be. There's no doubt in my mind.
Generally, if you've gone through the loan modification process and you feel that you were treated unfairly, then it's worth a phone call to Mark or to me so that we can talk about it with you. Go to our website, which is servicerlitigationgroup.com, and both Mark's and my phone numbers are there. They will talk, depending on if they call Mark's law firm, they will talk to Mark. If they call my law firm, they will talk to me. The lawsuits are not going to be easy, and so Mark and I, between the two of us, have over 60 years of legal experience, and we believe that we will be able to bring it to the banks. The amount of people that are being hurt by this, it's millions and millions of Americans. The American dream is being destroyed for millions of people so that a servicer can bill an extra $5,000 of costs on any given file.